So we want to get right to our panel. First, we have former Senator Russ Feingold, whose name is on the landmark 2002 law he co-sponsored with Senator John McCain, large portions of which were overturned in the Citizens United decision that you'll be hearing quite a bit more about. Senator Feingold represented Wisconsin in the United States Senate for 18 years, and most recently he served as one of the co-chairs for President Obama's re-election campaign. Thank you. Also joining us is Pamela Karlan, professor of public interest law and co-director of the Supreme Court Litigation Clinic at Stanford Law School. Another highly talented and prolific author. Pamela is the co-author of several case books, many articles, bi-monthly column, and has a special interest in voting rights, civil rights, and criminal procedure. And third, we have my good friend Jeff Stone, who is the Edward Levy Distinguished Services Professor of Law at the University of Chicago. As you know, Professor Stone has also published numerous books, his most recent one of which is Speaking Out, Reflections on Law, Liberty, and Justice. So let's turn it over to our panel, beginning with Jeff. Thank you all.
Thank you. My job this morning is really this afternoon, is just to lay the foundation for this discussion. So to make sure we're all on the same page in terms of the general background. In the early 1970s, Congress, concerned about the the destructive effect of money in the political process, enacted legislation that limited the amount that any individual could contribute to a political candidate, that limited the amount that any individual could spend on his own behalf for a political candidate, and limited the amount that a candidate himself or herself could spend to support a candidacy. The Supreme Court in Buckley versus Vallejo in 1976 considered the constitutionality of this legislation, and it more or less split the baby. What the court did is to hold that the contribution limitations were constitutional. That is, the government could say that an individual could contribute directly only a certain amount of money to a political candidate. But it held unconstitutional the expenditure limitations. That is, it held that the government could not constitutionally limit the amount an individual could spend to support the election of a particular candidate, or the amount that a candidate could spend to support his or her own election. And the basic premise of that argument was that a regulation of contributions was really a modest restraint on the ability of individuals to communicate, because they were still free, if the expenditure limitations were unconstitutional, to spend their money in other ways to achieve more or less the same result. But limitations on expenditures, the court held, profoundly affected the ability of individuals to participate in the marketplace of ideas in a world in which today money, in fact, has a great deal to do with the effectiveness of political discourse, and that therefore the First Amendment rights of individuals to spend as much as they wanted to support their political candidates could not be infringed in the way that the legislation had attempted to limit it. Over the next 2 decades, many problems arose in this scheme, and in the Bipartisan Campaign Act of 2002, the McCain-Feingold legislation, which took 7 years to craft and enact, Congress attempted to address many of the problems that had arisen by limiting limiting some of the speech activities, the expenditure activities of both individuals and corporations. In 2003, the following year, the Supreme Court in the McConnell case, Mitch McConnell, upheld the constitutionality of McCain-Feingold, finding, particularly with respect to corporations, that corporations could be limited in ways in which individuals, the court had held in Buckley, could not be limited, because corporations were artificial entities that had been created by the state, and that they were given particular powers by the state in order to enable them to be effective in the business arena, and that allowed them to accumulate huge amounts of resources for the purposes of economic activity, but the government could say that insofar as you're able to accumulate these resources, the purpose is for economics, not to dominate the political process. And that there was sufficient justification in terms of the fear of corruption and the appearance of corruption to justify the restriction on corporate speech. 7 years later, in Citizens United, decided in 2010, the Supreme Court overturned the McConnell decision. In a 5-4 decision, the court ruled that the restriction on corporate speech that had been imposed by McCain-Feingold and that had been upheld in the McConnell decision was in fact unconstitutional. And the court said that corporations, like individuals, have First Amendment rights, and that the government interests that are asserted in defense of the limitations on corporate speech were not sufficiently weighty to justify this impairment of the ability of corporations to participate in public discourse. Now, the only thing that had changed from McConnell in 2003 to Citizens United in 2010 was that Justice Alito replaced Justice O'Connor. That is, McConnell was a 5-4 decision, and Citizens United was a 5-4 decision. O'Connor had been in the majority in McConnell, and Alito was the 5th vote for the majority in Citizens United. So essentially the arguments in the two cases were identical, but now you simply had a change in the makeup of the court, which led the new majority to overturn the prior decision. So let me make a couple of final points to help focus the discussion. There are a couple of arguments that have been made in opposition to Citizens United that I think are not weighty and I think should be therefore quickly put aside. One of them is that corporations are not people. This is true, but it's irrelevant. The First Amendment says nothing about people, right? It says Congress shall make no law abridging the freedom of speech or of the press. And it doesn't say anything at all about people. In many other respects, the Supreme Court had previously held that corporations do have constitutional rights. And indeed, if you think about things like the New York Times or CBS, obviously they have to have First Amendment rights, even though they're corporations. So the argument that corporations are not people, which is a nice bumper sticker, actually does not carry the legal argument in a serious way. The second argument that's sometimes made that I think carries no weight is that money is not speech. This is another nice bumper sticker. It doesn't work. The truth is that no justice who has ever addressed these questions in the Supreme Court has ever adopted the proposition that money is not speech. Money is speech when it is used for speech. In the same way a draft card is speech when you burn it in an anti-war protest. Money is speech when it's used for speech purposes. When you go to buy a book, you're engaging in speech. If the government says no one may use money to buy a book, that would violate the First Amendment. Right? So the argument that money is not speech is a nice cliche. It does not help decide the question. One final point is a defense of Citizens United, which I think was wrong, but I think it's important to take seriously what the argument was. The primary best argument in support of the majority in Citizens United, in my view, was distrust of government. That basically when government attempts to regulate the process by which public officials get elected, there is every reason to be very suspicious about what's really going on. There's a serious fox in the henhouse problem, because you could be pretty sure that elected officials will be sorely tempted to do everything they can to assure their own reelection when they make these rules. And so if, for example, you have one party in control of the House, the Senate, and the White House, and they make rules governing the electoral process, you can be certain that it's going to benefit their party. And courts, therefore, should be very careful about upholding such rules. Similarly, even if it's bipartisan, there's a very strong risk that what it's really about is incumbent protection. Is that what the people who vote on these regulations are really trying to do is to eliminate their competitors, even if it's across parties. And so the argument would be there's very good reason to be extremely suspicious of government when it tries to make these regulations, and therefore, in the absence of a truly compelling and persuasive justification, these should be unconstitutional. Okay, one final point I want to make, or one final statement I want to make. How many of you were here a week ago when I participated in the panel? Okay, I apologize to you, because I'm going to tell the same story I did then, because it's even more apt today. Because it tells you a lot about the current state of affairs with respect to money in politics. So I was told this story by a friend of mine who works in the White House, who had been told the story by the president. And the story, which is true, goes like this. About 10 days ago, President Obama met in the Oval Office with a congressman from Ohio, and the congressman asked if he could bring his 5-year-old son, who happened to be visiting D.C., with him to meet the president. And the president, who likes children, said, sure, that's great. And so the little boy from Ohio comes into the Oval Office with his father, the congressman, and the president goes up and says to the little boy, do you know who I am? And the little boy looks up and says, you're Obama. And the president says, right. And he says, do you know what my job is? And the little boy says, you're the president. And Barack says, right. And the president then says, do you know what the president does? And the little boy says, he approves this message. And with that, I turn over the podium to Senator Russ Feingold.
First, what a wonderful thing the Chicago Humanities Festival is. I'm thrilled to be a part of it and honored. I'm especially honored to be with these two incredible individuals, two of the great constitutional law scholars of our time. When President Obama called me and asked me who should be appointed to the Supreme Court, I said to him, I think you ought to appoint Professor Pam Karlan. That was the name that I gave. And Professor Stone is just somebody...
I said the same thing.
And maybe he still will. But of course, Professor Stone is just one of those names that you, if you're a lawyer or even somebody that follows the law, that you revere, not only here in Chicago, but across the nation, as one of the great legal minds of our time. So what am I doing up here? Well, I did write this bill, McCain-Feingold. McCain likes to say, you know, in Wisconsin, they think Feingold's first name is McCain. That's one of his favorite jokes. He has about 5 jokes, and that's one of them. But this is a serious discussion about Citizen United. You know, I was called up by, of all publications, Variety magazine, which they don't call me a lot. I'm not one of their big sources. And they asked me, what did I think of what Stephen Colbert was doing with highlighting this issue? You know, he created a super PAC. And it was both funny and very informative. What I said was, look, I've been all over the country trying to explain the impact of the Citizens United decision, and I really appreciate what Colbert is doing. He's not as funny as I am, but he does a pretty good job of explaining. Of course, they didn't use that quote. It was the only good quote I had that whole 5-month period. You know, but this decision's only been around since January 21st, 2010. It's been one midterm election, one presidential election. And in my view, the decision, and this is the kind of language law professors don't use, but I get to use it, it was a lawless and recklessly activist decision that really cannot be justified. One of the reasons is, I think we all know that the Supreme Court is supposed to be a stabilizing influence in our society, and fundamentally, they are not supposed to reach a decision they don't have to reach. They're supposed to take a narrow ground, if at all possible. Well, this case was about a movie made about Hillary Clinton on DirecTV. It was not something that the McCain-Feingold bill was supposed to reach. I know, I wrote it. And so all they had to do was say, okay, it's not covered by this. The court chose to do something entirely different. They decided to say, corporations are people too. And I take a slightly different view, although I think the professor was being a bit provocative here, when it comes to the notion that corporations are in the same standing under the Constitution with regard to political speech. Of course, I agree that corporations have free speech rights. There's no question. When BP wants to run ads and say, look, we've cleaned up the Gulf and there's new jobs and come on down, I believe that's absolutely constitutionally protected. The question here is whether the notion, and that the founders intended, that corporations should have the ability to override the judgment of the American people when they have passed legislation saying we don't want corporations to be able to do that. And that, I think, is where the court went completely off track. Fortunately, there was a dissent in that case, of course, written by a Chicagoan who was appointed by a Republican, who was 90 years old, who was given his last time on the bench, and he made the justices listen to him listened for 25 minutes to a portion of his 90-page opinion, Justice Paul Stevens said of this decision of the court. At bottom, the court's opinion is thus a rejection of the common sense of the American people, who have recognized a need to prevent corporations from undermining self-government since the founding, and who fought the distinctive corrupting potential of corporate electioneering since the days of Theodore Roosevelt. And so, as Professor Stone was pointing out, what they did in this case was essentially, effectively overturn the Tillman Act. The Tillman Act in 1907, signed by Teddy Roosevelt, was a part of the whole progressive era response to the Gilded Age that said we don't want corporations to be able to use their treasuries to influence elections. So that had been the law of the land for over 100 years. And then in the Taft-Hartley Act, Congress and the President decided that the same rules should apply to unions as well. So in terms of what did McCain-Feingold do, one of the great myths in America is that McCain-Feingold's been overturned. That is absolutely false. A portion, frankly the portion I was less enthusiastic about, was overturned. The main holding of McCain-Feingold, the main point of McCain-Feingold, was to prevent corporations and unions from giving unlimited political contributions to the political parties. That's still the law. But here's the problem. It's like McCain and I saw this brick wall that had been built over 100 years. And we noticed that one of the bricks was broken. So we put in a new brick. And then the Supreme Court came along and smashed the entire wall, crushed it, and our brick's the only thing that's left. That's what happened. That's fundamentally the result of this decision. So if you want to say to somebody simply, what is the effect of this decision? For the first time in your lives, when you buy a tube of toothpaste or a gallon of gas, that money can be used for a candidate that you can't stand immediately. That had not been allowed in this country for over 100 years. And as I said, this was part of a great Gilded Age reaction to the Gilded Age. This was one of the bills like the Sherman Antitrust Act, like creating the FDA because of the exposing of the stockyards here, right here in the city of Chicago. This was what this was all about, and the United States Supreme Court in a 5-4 decision decided, oh, we can just toss that out. You know? So what if that was the judgment of the American people for over 100 years? Now look, I don't have anything against corporations. I think corporations are useful, but I appeared on Colbert one time, and he, of course, assured me in advance that my job was he's going to be an idiot, and I'm supposed to set him straight. Well, he gets on the air, and the introduction, he goes, we have recently deposed Senator Russ Feingold here. like Hosni Mubarak was coming on the show. And then he laid into me, so, Feingold, what do you have against corporations? If you see a corporation walking down the street, do you cross the street? Would you let your daughters date a corporation? But the point is, and I think Professor Stone set this up right, this isn't about saying that corporations don't have rights. It's about whether or not they can override this kind of legislation. I think they cannot. But in the limited time I have left, and I usually take an hour to just go through what I've just gone through, I wanted to introduce a few new things that I'm not hearing people talk about. What you're going to hear, and what you are hearing right now, is, look, Obama won anyway, all this money was spent, what's the big deal? Maybe this Citizens United decision didn't do anything. Well, let me tell you, compared to 2008, this decision and this kind of advertising and these kinds of contributions made a lot of people, young people especially, feel cut out of the political process. That their $10, $20 contribution that they proudly gave over the internet in 2008 didn't matter anymore. It's crushing psychologically to people's view of how their system works. And here's another problem. You're not always going to have a President Obama running in an election. He was able to fend off a lot of this simply because of who he is and the kind of organization he had. So I think it's unwise to suggest that this doesn't have an impact on the election. But it's not just about who wins the election. It's about corruption. There are private phone conversations going on, up until Tuesday, they're probably going on again now actually, where people are being called up and being asked to give $1 million, $5 million contributions. They don't have to disclose it. Now what do you think goes on in those conversations? We say in the Midwest, or probably all across the country, there's no such thing as a free lunch. I would propose there's no such thing as a free $10 million contribution. So it isn't just about the election. It's about corruption. What about this? What about our business community? Who do you think the new fall guys are of American politics? Corporations and unions and wealthy people. They can be hit up and pressured to give unlimited contributions in a way that I'm sure disturbs most of them. Most people just want to run a good business and don't want this. In fact, when we tried to pass McCain-Feingold for years, some corporate executives came to me and said, we want to help you. We think this is an awful system. But Feingold, you got to stop calling it legalized bribery. It's extortion. And I thought, they're right. It's not like a CEO sits at his desk and goes, hey, we got too much money laying around. I think I'll call up Chuck Schumer and give him some money. The call comes the other way. The call comes from the politician or the super PAC. So this is bad for business. When somebody exercising their fiduciary duty to their company has to play this game to keep up with their competitor, this is bad for our economy. Here's another question. Everybody talks about, look at all the money, look at the guy that gave the money, what is he up to? Who's going to get the money? How does it affect the election? But who got the money? Where did all this money go? It went to media outlets. It went to campaign consultants like Karl Rove, who was lying through his teeth on Fox News the other night because he's getting paid to continue this scam. It's a confidence game where people get all this money, and this is not being discussed at all. Finally, and most importantly, not only is it not just about the election and who wins, not only does it have to do with the effect it has in the private sector and what's going on in a corrupting way, it's about what happens after the election more than anything else. The buying of public policy in America. I know about this because this is what the soft money issue was all about. During the effort on McCain-Feingold, those were the years when we did various things like passing trade agreements that shipped our jobs overseas. NAFTA, most favored nation status for China. 83-15 vote. The Telecom Act of 1996, which destroyed a great deal of diversity in the media. One of the worst pieces of legislation ever passed. And this is under Bill Clinton, okay? 91-5. Needless to say, I was in the minority in all these, just for the record. Finally, and most disturbingly, both parties, because they were bought off by soft money at the time, decided, let's get rid of that Glass-Steagall law that we put in after the Depression. Let's let Wall Street run loose by a vote of 90-8. So what you get with this system, and it just happened, is both parties are bought off when it's time to sit down and vote. So don't let those who want to have corporations that dominate our democracy get away with narrowing the frame of this debate to, we don't, sometimes you win, sometimes you lose. This is much more fundamental. This goes to the heart of our very system and whether we're going to have a system of government that actually has anything to do with actual people having actual representatives who are going to vote in their interests. Thanks.
Well, you see now why Senator Feingold is my hero. So Jeff Stone started us off by saying, one of the problems is bumper stickers. So I'm going to give you 3 bumper stickers and then talk about them. The first of the bumper stickers is money is like water. The second of them is wait, it gets worse. And the third of them is freedom matters, but so does equality. So let me talk about those 3 points. The first one about money being like water. One of the things we've learned in American history is if you dam up a river over here, the water will flow somewhere else. Water seeks its own level. There is no way, given how important control of the government is to so many people, that you can drive all of the money out of politics. And so one of the critical questions to ask is, when you dam up the water over here, where does it flow instead? And starting with the Buckley decision that Jeff talked about, the Supreme Court has dammed up the water in ways and has restricted Congress and the American people's ability to channel the water in ways that drives the water into ever more disturbing and dangerous channels. And so we see this time around in the current election, it's not just that corporate spending has gone up. It's that huge amounts of spending now are done in ways that make it impossible even for intelligent and informed voters to know where the money's coming from and what the conversations before it are. If you go back to 1974, when the modern era of campaign finance began, most of the money went to candidates and parties. At least the candidates have to be responsible on election day to the people who elect them. At least the parties are in the business for the long haul and are trying to build big tents. But that money has been forced more and more into single issue groups, into super PACs, into 501c4s, which don't even have to disclose their donors, so that now things have gotten worse. You don't know where that money is coming from. And I want to emphasize this point also because today we're thinking all about the presidential election. But much of this money is going into local elections. It's going into judicial elections. It's going into elections for water and water storage districts and like. And there's no way of tracing that money. The press doesn't cover it. You all know who Sheldon Adelson is, but most of you probably don't know who the people are who are spending $400,000 on judicial elections and the like. And that's a real problem. Money is like water. If you dam it up over here, it's going to flow somewhere else, and the Supreme Court has made it difficult to dam the water up and channel it in intelligent ways. Second, it gets worse. Everybody in the room has heard of Citizens United. Probably that's what drew you to this particular panel. But I want to just ask you, how many of you have heard of American Tradition Partnership Against Bullock? Don't see a whole lot of hands up. How many of you have heard about Arizona Free Enterprise Club's PAC against Bennett? Don't see a lot of hands up on that. How many of you have heard about SEIU against Knox? Gosh, not a hand up about that. Oh, one hand, great. Back. Two hands. You heard about it from her because she's sitting right in front of you, right? Yeah. Well, these are the Supreme Court's 3 most recent campaign finance decisions after Citizens United. I want to tell you just a minute about each of them. So American Tradition Partnership Against Bullock was about Montana's ban on corporate spending in Montana. And one of the things the Supreme Court said in striking down the corporate spending limits in McCain-Feingold is, we don't think there's a serious risk of corruption. And without a serious risk, we don't think these limits are acceptable. Well, in Montana, they passed this law in 1909, and it wasn't either one party passing it, it wasn't even a bipartisan Incumbent Protection Act, it was an initiative in Montana, passed after the copper companies took over the legislature and the courts. They just bought them off. So you might think, faced with a law like this, the Supreme Court would hear oral argument and look at the history of the law and see what its effects were. You might think that, but if you thought that, you'd be wrong. Because last year, in the last week of the term, while everybody was looking at the health care case, the Supreme Court struck down the Montana campaign finance statute without oral argument, without looking at the evidence at all. And here's the saddest thing about it. The 4 members of the Supreme Court who dissented said, there's not even a point in having an oral argument in this case, because we can see the majority's mind is made up. So we've moved from Citizens United being an empirical prediction about does money corrupt, to the Supreme Court now saying, we've decided money does not corrupt. That's a first principle, not an empirical projection. So we don't need to look at anything that's happened since 2010, where 70% of the independent spending this time around was spent by groups who would not legally have been able to spend the money in 2006. We don't have to look at that at all. Then you might say, well, what about the fact that McCain-Feingold was limiting both unions and corporations. So we've now given both unions and corporations the right to speak more freely in American elections. Well, in SEU against Knox, the Supreme Court 5-4 last year, end of the term, said unions can be restricted in how they raise the money they spend in campaigns. Corporations can't. So if you buy a tube of toothpaste, as Senator Feingold said, you're buying into whatever Crest or Procter & Gamble wants to do with money. But it's even worse than that, because most of you presumably have pensions or pension plans. And your pension plans have to buy corporate stock. That's how they deal with pensions. So you can't even refuse, you could refuse to buy the toothpaste of the company you don't like, but you can't refuse to contribute to your pension plan. And now you're put at war with yourself, which is, if you want to save money for your retirement, you have to invest it. And now when you invest it, you're being forced to subsidize the corporate speech of the corporations you're investing in. So I think that's worse as well. And finally, the Supreme Court in the Arizona Free Enterprise Club PAC case held that most public financing systems are going to be viewed as unconstitutional. Because if public financing systems say to candidates, if you accept money from us, you agree not to raise money from anywhere else, those public financing systems can't give candidates more money if their opponents raise more. The Supreme Court says it's like penalizing free speech to subsidize the speech of candidates who are willing to forego public contributions, which means that realistically, most candidates are not going to buy into public financing systems because then their opponent can raise unlimited funds and they're limited by the initial grant from the public financing system. So it's worse than it looks. And finally, freedom matters, but so does equality. Here's the thing that most upsets me about Citizens United, which is the Supreme Court there said, we understand that one of the arguments for campaign finance and limitations on political spending is to equalize the playing field, to level the playing field. And the Supreme Court says that's illegitimate. Leveling the playing field is illegitimate. So in the kind of tension between freedom and equality, freedom, a particular kind of freedom, the freedom to spend as much money as you want, trumps equality. It trumps one person, one vote. It trumps all of the other values in the Constitution that go to equality. And I'll just end by putting campaign finance in a larger perspective. And the larger perspective is this. Money is like water in the sense also that it's part of an ecosystem. And politics is an ecosystem. And one of the things I find most distressing about the current Supreme Court is the way that that court says, we don't have to worry. We don't think, Justice Kennedy says in Citizens United, we don't think that you have to worry that people will lose confidence in the election system simply because lots of money is being spent in it. Now, he might be right about that. I think he's wrong, but he might be right. But here's the thing. If you're going to say that we don't think claims that people are going to lose confidence in the election system justify restricting freedom, then how is it that the Supreme Court, the same Supreme Court, held that we can have voter ID laws in this country because voter ID laws increase public confidence in the election system? That is, how can it be right? How can it be right to restrict individual voters' rights to go to the polls because of an illusory fear about public confidence, but it's wrong to limit the amount of dollars that go into the polls because that has no effect on public confidence? That's what worries me most, is that we've gotten so fixated in this Supreme Court on a kind of libertarian view of the ability to spend as much money as you want to influence the system that we've forgotten at the end of the day, this is about elections, and in America, everybody's voice is supposed to count equally in the electoral process. Thanks very much.
We'll now open the floor to questions. There'll be some people with microphones out there, and they will raise your hand, and they will find you. And when you do ask a question, please identify yourself and make it a question.
We have a question. We have a question back here. Let's make sure it's working.
That's not working.
Test, test. Okay.
There you go.
We have a question in the back.
I'm wondering, in addition to Citizens United, we hear so much about lobbyists. A lot of money being put into political campaigns and individuals. I wonder if you'd comment on that.
Well, this is obviously part of the issue. It's not that lobbyists themselves give huge campaign contributions. It's that they become conduits for collecting large contributions. So in Washington, typically a member of the House or Senate will be having a, quote, fundraiser. And the lobbyist will bring in a few people and a bunch of checks. And this is, this is the same lobbyist who's arranging to have meetings to talk to this guy. about policy in his office the next day. Hopefully they're not doing the same thing in the office, because that's illegal. But I mean, it's across the street, you know, at the 201 Club, or, you know, at the Monocle. So there used to be another element of this practice, which was gifts for members of Congress. We shut that down, and then there was a loophole. McCain and I shut that down, and then I did it with Obama. We sort of tightened that up again, but they always find another way. And now, when these organizations can be represented by people who can talk about, you know, we're thinking about creating a super PAC. They're not talking about $10,000 contributions, which were the limit for PACs after the Watergate era. They're talking about the potential of millions and millions of dollars either for the person or against the person. And it's simply terrifying for public officials, and it is one of the serious consequences of Citizens United, although lobbyist problem was already a problem before that.
Okay, we have a question on the far side.
Hi, my name is Jill. Senator Feingold, you talked about the fiduciary duty that corporations have when they give this money. My question would be, with Sarbanes-Oxley and they're publicly traded, wouldn't we be able to see that they gave this money? Wouldn't they have to disclose that somehow they contributed to these super PACs?
You know,
and
I don't
if
know
so, could we hold them accountable through shareholder, you know, suits of some type saying that we think you misused the money?
I'm not absolutely certain about the answer to that, but one of the great opportunities in this area for reform is on the corporate reform side, is on the shareholder side, is on either states or the federal government passing legislation of that kind. And, but the point is, it isn't necessary. It's something that hopefully shareholders could say something about, but I'll never forget that Fred Smith, who created FedEx, one of the great concepts of our time, he asked to come to see me when I kept railing against this stuff. And he came in my office and he said, Russ, we didn't set up this system. I'm fighting UPS. I'm going to give this $200,000 contribution. I don't want to do it, but how else do I explain to my board of directors and my shareholders that I'm fighting hard enough for our side? So, yes, I think that has potential, but I'm not going to pretend to know the specific answer about Sarbanes-Oxley.
Okay, we have a question on this side.
Hello, my name is Trudy Gardner, and I have a question. Do you favor the constitutional amendment that's currently being advocated by some groups, and if so, why? If not, why not?
Well, there are several different versions of a constitutional amendment that have been put forth. I think that if that were necessary to overturn Citizens United, I would support it. I think Citizens United is so destructive to the American political system that it needs to be overturned. And there are realistically only two ways of doing that. One is a change in the makeup of the Supreme Court that eventually either erodes or overturns Citizens United. And the other is obviously a constitutional amendment. In general, I'm not in favor of leaping too quickly to constitutional amendments. I see that as a dangerous avenue because there are lots of issues on which people might want to amend the Constitution, and on most of them I think I would probably be on the other side. And in any event, it's hard to believe that a constitutional amendment is a viable option. Given what is necessary to amend the Constitution, it's very hard to see politically how it would be possible to get from here to there. But on the other hand, I think the movement for a constitutional amendment is healthy because it keeps this issue alive, it keeps people energized about it, and if it were actually possible to do, and we could draft an amendment that made sense, that's the tricky part, I think I would support it. My own view is that if I were drafting that amendment, it would say something along the lines that Congress and the states shall have the authority reasonably to regulate money in the political process in such a way as to make elections more fair and equal.
Okay, we have a question on the far side.
I think we have other answers.
I think, though, the problem is until you change the Supreme Court would read Jeff's amendment and say, well, this law isn't necessary. And I think, you know, that's really the problem, is drafting an amendment that a court that's hostile to the very concept of the amendment then passes on is a really hard thing to do.
And I just want to address, I completely agree with the way Professor Stone set this up. It is terrific that people are doing this, particularly young people are providing an energy who are supporting the constitutional amendment that's making a big impact. But my two caveats are, first of all, I chaired the Constitution Subcommittee for many years of the Judiciary Committee, and I saw these amendments. We've never amended the Bill of Rights in the history of this nation for any purpose Let's think twice before we do that. Secondly, what happens if we put all that energy into the constitutional amendment instead of a disclose act, instead of public financing, instead of overturning the decision? It's like pushing us over a cliff because it is so hard to pass a constitutional amendment. So I would add those sort of more political observations.
Can I just add one last thing on this, which is about the public financing? This election was the most expensive election cycle in American history. I think there was $6 billion spent on everything. I mean, that's from, dog catcher on up. 60 million people voted. So that's basically $100 per person who voted. We get the democracy we pay for in a way. And because we don't finance the campaigns do get financed by wealthy individuals and wealthy groups that can afford to finance them. If we paid more, we would have elections that were better run, and we would have elected officials who were more responsive to everyday people. And until we do serious public financing, I don't think we're going to get serious campaign finance reform.
My name is Betsy O'Brien. This morning I read with...
Joe, can you hold it closer to your mouth?
Sure, is that
Thanks.
better? I read a news article this morning with some shock and interest. This was about an employer who had required his employees to go to a political rally for one of our presidential candidates. He is now laying off employees, claiming that now that Mr. Obama has won, he won't be able to be profitable in the future. My question is, does Citizens United and the thinking that surrounds it embolden employers and give them the right to do this, to create what I would say would be a climate of harassment toward a Democratic voter who may work there? And if so, is there any legal redress for employees? What can we do?
Pam, you like that?
Well, so it's a complicated question. It's clearly, deeply immoral, but the question is it illegal as well? And generally, the question depends on state law. There's no federal law that protects employees of private businesses from discrimination on the basis of political affiliation. There's federal law that protects employees of public employers, namely the First Amendment and the 14th Amendment, but not of private employers. So the question is, in the state that a particular individual lives in, what are the state law rules? And that varies from state to state. What you might see from a Supreme Court that takes the extremely strong pro-First Amendment autonomy position of the current court is it's freedom of association. If you don't want to associate with people who don't share your political beliefs, you don't have to. And if that means you're an employer who doesn't like your employees' political beliefs, then you should have the right to fire them. That would be the strong libertarian First Amendment position. So that's about all I can say.
And your case is slightly different than this, but what emerged in the last few weeks of the campaign is that because of Citizens United, employers can now use the resources of a corporation to send letters to their employees that say, don't vote for Obama because I'm going to have to lay people off. Let the professors correct me if I'm wrong.
Right.
But this is one of the most insidious aspects of the decision that's hardly even been considered and has hardly even been exploited. So whether or not somebody can, it's different to say require somebody to go to a rally, I think would raise other issues. But this is a whole new, brave, new, scary world of what corporations can do.
Yeah, I want to just underscore the point that Pam made about the potential of this group of justices to hold that a regulation that prohibits an employer from firing people because of their political views would violate the First Amendment. In Boy Scouts versus Dale, a majority of conservative justices held that the Boy Scouts had a First Amendment right to fire gay scoutmasters in the face of an anti-discrimination law that declared that illegal. So even if there were a law that prohibited employers from firing employees because of their political beliefs, this Supreme Court very well would, I think, be likely to strike it down on the grounds that it violates the First Amendment rights of the employer to force them to have employees who disagree with them politically, which is crazy. But
My name is Jane, and I would like to ask each of you if you have a realistic suggestion going forward.
For what?
Going forward. Realistic suggestions for going forward.
On this issue.
On this issue, yeah.
All right, you have to operate at several levels. First of all, apart from the issue of a constitutional amendment, we need to organize to get this decision overturned. The first thing you need to do is re-elect President Obama. You did it! Okay? Next thing you got to do is hope that we get some vacancies in the Supreme Court. Okay? To me, that's the most efficient. But in the meantime, there's a lot of legislative things that can be done to mitigate this problem. The passage of disclosure legislation at the federal and state level. California is one vote short on this. The passage of public financing legislation, fixing the presidential system, which has been wrecked, as well as having for the first time House and Senate races being that way. Pass a law to make these phony super PACs exposed, where somebody has their campaign manager and their chief of staff go over and say that it's an independent group. That can be tightened. Get rid of the Federal Elections Commission, which is a joke, and put in place a real enforcement agency. These are all things, this is just a small list of things we can organize behind, and I believe in the idea of lifting all boats on this. It's like, let's not argue exactly about what's the right solution, the wrong solution. Let's all help each other highlight these issues and do these things. That's how I think we should move forward.
I'm with him.
I'm with him too, but I want to offer one complication to the scenario of changing the Supreme Court, because I think it's really interesting, and we may or may not confront it in the next 4 years. The only way that a change in the Supreme Court would affect Citizens United is, of course, if one of the 5 conservative justices were to leave the court for whatever reason, and President Obama, who we've reelected, would have the opportunity to nominate a successor justice who presumably would take a different view than the departing justice on Citizens United. And then the question you have to ask yourself is, would the Republican Senate, it's a Democratic Senate, but the Republicans can filibuster, would they ever confirm any nominee who they thought would overrule Citizens United? And that raises real questions about how realistic is the prospect of changing the court in the way in which it should be changed, even if President Obama has the opportunity to make such a nomination. It will be a really ugly battle. Thank you all very much for coming.